Wolf, thank you so much. Hi there, I'm Brooke Baldwin. Thank you for being with me here on this Wednesday. We have to begin with these new details in this tragic story of a Georgia toddler who died, whose lifeless body was pulled from his father's sweltering SUV. So that child, here he was, 22-month-old Cooper Mills Harris, died last week. Cooper's father told investigators he forgot that his son was in the back of his car in that rear-facing child seat. Didn't take the child to daycare. Now this dad's story is falling apart. Police say 33-year-old Justin Harris knew his son was in that roasting SUV and that there is evidence to prove it. Harris is charged with murder, and we have this new arrest warrant just in today, just released, details why police believe Cooper's death was no accident. But there is one other detail in that same warrant that raises questions about criminal intent. So with me now, a host of people here to walk me through this. CNN correspondent Victor Blackwell, who's there in Cobb County, criminal defense attorney Holly Hughes, and former Cobb County prosecutor Philip Holloway. So welcome to everyone. And Victor, let's just begin with you there on the ground. With this criminal warrant, specifically two nuggets, two takeaways here. Number one, the breakfast before this horrendous incident took place, and two, the lunchtime trip to the car.
Let's start at the beginning of the day, Brooke, where, according to this warrant from Cobb County Police Department, Justin Ross Harris was seen. So that suggests that there's surveillance video. He was seen having breakfast at this Chick-fil-A restaurant not far from his home and from his workplace, and placing little Cooper into this car seat in the rear seat, rear-facing, in the center of that seat. So that suggests anyone who has a child and they use a car seat, if you're in the driver's seat and you look into that rear view mirror, you can see what's between the headrests, and he would have seen that child in that seat. That, again, is according to police. That's the morning. Then he drove to work, went into his job at the Home Depot Service Center, and according to this warrant, Justin Harris was seen going back to that vehicle during lunchtime, opening the driver's side door, placing something inside, although there's no details about what was placed inside, closed the door, and then walked back into work. Of course, that suggests that he knew that his son, 22 months old, was inside that vehicle. The temperature that day outdoors, Brooke, 88 degrees. Experts say that it could have quickly gone up to more than 120 degrees inside that Hyundai Tucson.
Okay, Victor, stay with me. Let me just broaden the conversation out here with Philip and Holly. First, to the point about the breakfast, because initially when I read this criminal warrant, it's very easy to think, my goodness, this father had breakfast with this 22-month-old boy. You picture him feeding him a chicken biscuit at the Chick-fil-A before going all of a mile away to work. But we don't know, first of all, whether this child was asleep in the car. We don't know yet whether he got this child out. Could have been a drive-through.
We don't know, and the thing is, that Chick-fil-A is so close to where he worked. There's no way in the world a child could have fallen asleep and you just forgot about him in that short period of time. And that's an amazing detail. Just last week, they led us to believe, by dripping out some information, that this was going to go in a more different direction, a more sinister direction. And now to find the charges downgraded is a little bit surprising.
Let's take a look at the map here. We have it right over my shoulder. So you can see here the Chick-fil-A starred. That's where, according to this criminal warrant, he did stop the morning of to grab breakfast just across that highway, Home Depot headquarters, where he hopped over to work, and then ultimately drove up to Acres Mill Shopping Center, not too far away in Atlanta, and that's when, according to witnesses, he found the child, was screaming, "Oh God, no," tried to resuscitate this child. When you and I last spoke, I think it was just even on Friday, we were talking about this DA in Cobb County and how it's up to the DA to come up with these charges.
Correct.
And there had been this outcry that this could, and it still very well could be, an accident, and so part of the charge now is downgraded.
Yes, it has. It's been downgraded, and what we're talking about is felony murder here in the state of Georgia. We don't have degrees. You know, we all hear, oh, murder in the first. That's not what we're talking about.
Okay.
Felony murder means you're in the commission of another felony and somebody dies as a result. You're then on the hook for murder, even if you didn't intend, you didn't set out to kill anyone. But what you have to intend is you set out to do the underlying felony. And what they've downgraded it to is they've taken it from cruelty to children in the first degree down to cruelty to children in the second degree, which just requires criminal negligent. Your behavior was so outrageously negligent that you can then be on the hook for murder, even though you didn't intend to kill and you didn't intend to really do that awful harm to the baby. But you're just so outrageous in your behavior, and that's kind of what we're hearing, because 3 times, Brooke, you put the baby in the car at home, you see the baby when you're at Chick-fil-A, but then you go out at lunchtime and put something in your car, and you don't tell the police that. That's what's really
let me read
killing him right now.
That's the key, too, as part of this criminal warrant. This is during lunch, said accused did access the same vehicle through the driver's side door to place an object into the vehicle. Said accused then closed the door and left the car, re-entering his place of business. As Victor pointed out, it's a rear-facing child's car seat. So one could think maybe it was more difficult. You didn't see that the child's face sitting in the back seat wasn't facing forward. That could be something that the defense could say.
And that's exactly right. To your point, and mentioning the district attorney and his charging decision, I know the man personally.
You worked in Cobb County for years.
Well, and he's an honorable person. He's a very good lawyer, and he's somebody who knows how to analyze the totality of the circumstances and look at all the evidence in the proper light. And there's obviously things that he knows that we don't know. So while I'm surprised that the underlying felony of cruelty to children was downgraded to the 2nd degree, I've got to trust that he knows what he's doing and that he would not have lowered the charges unless there was a good reason to do so.
With the charges lowered, let's say that looking way ahead, if this father is convicted, how many years are we talking?
Life. It's a mandatory life sentence in Georgia for felony murder, even if you did not have any intention to kill. And as she said, all that's required is criminal negligence, and there's a fine line between mere negligence and criminal negligence, but either way, it's the absence of an intention to kill. And if it comes down to mere negligence, that could even give rise to a defense of accident or mistake or maybe some misdemeanor charges.
It's just it's a stunning story. It's a tragic story. It's the kind of story, I mean, just checking, thousands of people have been signing these petitions wanting this DA to downgrade the charges because of this uproar. I read in the Atlanta Journal-Constitution this morning, we'll have the reporter on next hour, saying people have raised, as far as donation goes, $20,000 to the family who we haven't heard from yet. And listen, if I was the mother, having lost my 22-month-old, I wouldn't want to talk to me either, but we haven't heard boo.
Well,
and that's so unusual, Brooke, because think about all the stories that we have covered over the years. How many times do people get behind the defendant, the one who's charged with the crime, and rally for the defense and say, cut him free, let him loose? That never happens. And what has changed here is just what the prosecution has to prove, not the sentencing. This man is still looking at a life sentence if convicted. So for him, his risk and his exposure is still that life sentence. And bear in mind, in the state of Georgia, that's 31 years before you're even eligible for parole. I mean, a life sentence is pretty close to a life sentence. It's going to get real high for him. So the only thing that's changed is what the state has to prove. They don't have to prove that intent to kill, just that criminal negligence. And that's what makes this case so different. And I think the reason we saw so many people initially get behind this defendant is because we think, I could forget that. I can see myself doing that.
Some parents are saying, no way.
Correct, right, exactly. But now with the additional facts,
when you hear that it's only a half a mile away, and how can you possibly forget that your 22-year-old or 22-month-old is back there?
In and out of the car several times in a day.
We'll follow this. We know that search warrant has to come out. More information will eke out in this case. Philip and Holly, thank you both very much.
Thank you. My
pleasure.
pleasure.